Good morning, this is your Kelso Report for Wednesday, August 15th, and I'm your host, Clark Kelso. Now, if you're anything like me, you've probably wondered when a gossip magazine publishes the personal photos of a celebrity, whether that publication is actionable as a copyright violation, or a violation of the right to control one's name and picture. Well, the Ninth Circuit faced the copyright question in Mong versus Maya magazines, which involved previously unpublished photos of a clandestine wedding between two Latin American celebrities. A magazine that makes its money by publishing celebrity photographs, and a paparazzo who apparently stole the disputed pictures. The music celebs sued the magazine for copyright infringement. The district court granted summary judgment to the magazine on the ground the publication of the images was a fair use. Now, I'm sure you remember the four non-exclusive statutory factors that courts are directed to use in evaluating a fair use defense. First, the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. Second, the nature of the copyrighted work. Third, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And fourth, the effect of the use upon the potential market for or value of the copyrighted work. The Ninth Circuit balanced these factors and by a 2-to-1 vote reversed the district court, concluding that the magazine did not sustain its burden of establishing that its wholesale commercial use of the previously unpublished photos constituted a fair use. This is a big loss for the magazine and paparazzis, and a big win for celebrities. Because if this decision holds, it puts control over a celebrity's unpublished pictures back in the hands of the celebrities. The dissent focused on the newsworthiness of the pictures and complained that the majority's fair use analysis is inconsistent with Supreme Court precedent and thwarts the public interests of copyright by allowing newsworthy public figures to control their images in the press. It seems to me that the majority has the better of the argument here. The pictures at issue here were taken privately and deliberately not published. The majority's holding preserves a celebrity's ability to keep private pictures private, or, in the alternative, to commercially exploit such pictures by authorizing publication for a price. Next, we have an evidence law question that arises in the context of eminent domain. The city of Corona sought to acquire certain property by eminent domain. On cross-examination of the city's valuation expert, the owner sought to introduce evidence of valuation that was inadmissible under Section 822A of the Evidence Code. That subdivision provides that in an eminent domain proceeding, 6 specified categories of evidence are, quote, inadmissible and shall not be taken into account as a basis for an opinion as to the value of the property, close quote. For example, the section excludes evidence of the value of so-called comparable properties, and it excludes evidence of properties that were taken by eminent domain, and it excludes evidence of offer prices. The owner appealed the exclusion of the evidence, arguing that Section 822's limitations should apply only to the direct introduction of evidence and should not apply to the owner's cross-examination of the city's valuation expert. The 4th District rejected this argument, concluding that there is no general cross-examination exception to the rule stated in Section 822A. Prior case law has allowed a party to an eminent domain proceeding to impeach an expert with a prior inconsistent valuation by that same expert. But the owner in this case did not offer any such prior inconsistent valuation, and instead wanted to cross-examine the witness using valuation evidence that was clearly not admissible under the Evidence Code. Lastly, we have a whistleblower case involving a health law. One of the basic principles of administrative law is that an aggrieved party should exhaust his or her administrative remedies before seeking further review. Well, a similar issue arose in Phelan versus Sutter Central Valley Hospitals, where the plaintiff, a physician whose privileges were taken away by the defendant hospital, sued for damages under Section 1278.5 of the Health and Safety Code, which is a whistleblower protection law designed to encourage healthcare workers to notify authorities of suspected unsafe patient care and conditions. The plaintiff alleged that his privileges were revoked in retaliation for his whistleblowing, and the issue before the 5th District was whether a doctor claiming he lost his hospital privileges as a form of whistleblower retaliation must still exhaust his judicial remedy of pursuing review via writ of mandate of the hospital's action in withdrawing privileges before he can file a whistleblower lawsuit under Section 1278.5. Well, recognizing that Section 1278.5 was enacted to encourage employees to report threats to public health without fear of retribution, and that an exhaustion requirement would substantially delay the doctor's whistleblower suit, particularly if there had been retribution, the 5th District held that exhaustion was not required, and the physician could come straight to court under the Health and Safety Code with his lawsuit for retaliation. And that's it for today's Kelso Report. Have a great day in the law.